Good evening, everyone. I, Advocate Nisargaraj Garje, am incredibly honored and grateful for the opportunity to anchor this event. Honorable Justice Shri Manish Pitale, President Advocate Yogita Thorat Ma'am, and the Secretary Advocate Shri Krishna Chaudhary Sahib, and all my respected seniors and colleagues. This lecture series is especially significant for us. This is our first lecture after being elected as the new committee. It's a great pleasure to see so many of you here today. Your presence shows just how much we value learning and growing together as a lawyer. Now, I would like to request the President and Secretary of Bar Association, please come forward and welcome Honorable Justice Shri Manish Pitale Sahib. Now, I request the Chairman of Bar Council of Maharashtra and Goa, Shri Amol Sawant Sahib, to felicitate Justice Manish Pitale Sahib. Thank you, sir. Now, I request the President of our High Court Bar Association, Advocate Yogita Thorat Ma'am, to say few words and introduce our guest of honor.
Thank you, Nisargaraj. Respected Honorable Justice Sri Manish Pitale Sahib, my esteemed seniors, learned colleagues, and my dear young friends. It gives me immense pleasure and a deep sense of honor to welcome you all on behalf of Advocates Association, High Court Bench at Aurangabad. Today marks a significant moment for us as we begin our lecture series with the gracious presence of Honorable Justice Manish Ji Pitale Sahib. He is fortunate to us that he is our administrative judge. His wisdom, integrity, and judicial vision are a source of inspiration for the entire bar and especially for our young generation. On this proud occasion, I extend my warm greetings to each one of you and express my heartfelt gratitude to our honorable judges. And today's marks of the beginning of our very first lecture in this series. This is not just the academic exercise, but a platform for learning, growing, and inspiring to each other. I am confident that this initiative of enrich a knowledge, strengthen the bar and bench bond, and guide our young lawyers for the benefit of their future. I am very thankful to Honorable Justice Manish Pitale Sahib accepted our invitation for a topic on where he want to deliver the lecture, that is law of writs. It is very legal remedies which are available in the Constitution. So thank you, Pitale Sahib ji. And again, I hand over to the Nisargaraj for further. Thank you.
Thank you so much, ma'am. The topic for today's lecture is on writs. Learning about the crucial subject from an expert like Honorable Justice Manish Pitale is a chance we don't get every day. With great respect, I now invite Honorable Justice Shri Manish Pitale Sahib to begin his lecture. Thank you.
the President and office bearers of the bar, government pleader, uh, advocates, young, middle-aged and old, ladies and gentlemen. It's a privilege, a pleasure to be here amongst all of you. I've been here as the administrative judge for about 8 weeks now, and the way our bench in court number 1 is functioning, I was not sure whether the hall would be full like this. But I believe what happens in the court is left in the courtroom. And I can assure you that as judges, what we do from the bench is being as if done by somebody else. It's not me who you see here in the hall. I'm a different person here. On the bench, it's a different kind of a onerous duty that we perform. And it's with the cooperation of the bar that we ultimately serve the ultimate recipient of the service that we are supposed to give, and that is the litigant himself or herself. So when things happen in the courtroom, there are exchanges, sometimes even heated exchanges. You have to keep this in mind, that this is all because the bar as well as the bench is concerned about the ultimate good of the litigant. So you try to convince as best as you can. We take a view which we think is in the interest of justice. And I am a firm believer that the courtroom or the court is not a court of law, not just a court of law. It's a court of justice. Of course, in accordance with law. But for me as a judge, justice is the ultimate aim. And therefore, in that process, if some of your arguments get trampled, you shouldn't feel bad, because the intention is to ultimately do justice. So with this preface, let me start my presentation today. Today, this is all about law of writs. Nothing is original that I would be saying. You must have read commentaries. But what dynamically happens in the courtroom when writ jurisdiction is exercised is something which I can talk about with little experience of about 8 years as a judge. I remember I came here in 2018 as a visiting judge. Incidentally, at that time also Mr. Girase was the government pleader. And I was sitting as a junior judge in a division bench with Justice Varade, who is now in the Supreme Court. And that time, at the request of the then president of the bar, I had given a lecture on the role of advocates in reducing pendency in courts. Now, that is also an aspect I might touch upon when I talk about the law of writs. If we go back in history, how did writ jurisdiction or writs arise? We have to look at the word itself. Writ literally means a written command. And if we go back to the origin of that power, we find that Norman kings who were ruling in England, particularly Henry VII, developed this group of people around him with whom he used to move around and look for situations where certain commands could be issued, which he thought would advance the cause of justice. So that's how the origin of the word writ. And the chancellor there used to draft what the king used to indicate is to be the writ, which used to carry a seal, an official seal of the king, and used to become an order or writ served upon the party which had to obey a particular command. So that's how this started. And as we know, we are all influenced by English jurisprudence. So as writ jurisdiction or writ jurisprudence evolved in the UK, it was transmuted, transformed into our constitution, and we have tweaked some changes according to our ground realities and needs. So you will find these named writs of mandamus, certiorari, prohibition, quo warranto, habeas corpus in Article 32 as well as Article 226 of our constitution. And if you go to the debates, you'll see that Dr. Ambedkar, the architect of our constitution, he insisted that these writs, named writs, must be mentioned in the articles of our constitution. And the reason perhaps was that he thought that the rich heritage of English law and writ jurisprudence, it should be incorporated in our constitution so that the evolution of these writs is straightaway taken down and implemented in our jurisprudence also. But if you see the difference between 32 and 226, Articles 32 and 226, you will immediately realize that 226 is certainly a wider jurisdiction exercised by the High Court. The Supreme Court in so many judgments has said that Article 32 is really concerned with fundamental rights, Part 3, And if the words used in the Article 226 are looked at, it not just says it is for enforcement of any rights conferred by Part 3, but also for any other purpose. Now, this "for any other purpose" becomes a very crucial phrase, because you will see over a period of time how high courts have widened their jurisdiction in Article 226 to do justice wherever it is needed. In fact, Supreme Court uses the phrase in one of the judgments that writ jurisdiction exercised by the High Courts under Article 226 of the Constitution must reach injustice wherever it is found. So there can't be much debate about the fact that this is an extremely wide jurisdiction, and it is to be exercised by the High Court with that much responsibility. I will come to what I feel for the Aurangabad bench needs to be focused upon a little later. But first, we must acknowledge the fact that this is a plenary power, and a power which is distinct from appellate jurisdiction. It is necessarily supervisory jurisdiction. Although we might not confuse this 226 with 227, the distinction is well known, except that Suryadev Rai and other judgments of the Supreme Court say that certiorari and 227 appear to be merging into each other, because ultimately it's supervisory jurisdiction that is being exercised. But the fundamental difference, of course, is, which all of you I'm sure know, that when 226 writ is exercised, the court essentially sets aside an order or examines the correctness of an order and takes corrective action. But in 227, the court can go further and give it can supplant its opinion, it can give further directions when 227 is exercised. But 226, I think the real engine, the powerful writ that we have is the writ of mandamus. Because if you look at, for instance, quo warranto, you won't have too many cases of writ of quo warranto being argued. Incidentally, there was one argued today before our division bench, very interesting matter. And habeas corpus writs, of course, are restricted to, in our jurisprudence, to the criminal division bench. But habeas corpus, quo warranto are the only writs which don't ask the question regarding locus standi. Otherwise, you have to show your locus standi to make out a case as to why should the court entertain a writ petition. I have found over a period of time that there has been a tendency to invoke mandamus in all and every kinds of situations. So the real test of an advocate, I believe, is when we talk about writ jurisdiction or writ jurisprudence, is that when a litigant comes to you and says that this is, I believe this is injustice that I am suffering, how do you find a solution for me? Because this is a plenary power and the High Court exercises such wide power under Article 226 of the Constitution of India, there is a temptation to file matters under this jurisdiction, this jurisprudence, and insist upon positive orders from the High Court. But I believe that the job of an advocate, first of all, is to identify what the real cause of action is, what is the real grievance of the litigant that comes to your office. And if you put in that effort, if you study, if you open books, you will realize that for every type of grievance, most of the acts, statutes, rules, and laws provide for a grievance redressal mechanism. So first of all, you must open books and find out. I'm surprised sometimes where grievances pertaining to, say, Trusts Act, Cooperative Societies Act, other statutes are freely being raised in our petitions filed under Article 226 of the Constitution of India. So the first job of an advocate, I believe, is to look for the real root of the grievance of the litigant and see whether there is a grievance redressal mechanism already provided. If that be so, then that mechanism should be first resorted to, and there would be situations, of course, where you ultimately may end up in a writ court, but that would be, if it is arising out of, say, a quasi-judicial proceeding, it goes under 227 to the single judge of our court. But then, after you eliminate all of this, would you realize that, yes, this is the matter which can be safely filed before the division bench of this court under Article 226 of the Constitution of India, with least chances of the courts asking you this basic question as to how is your writ petition maintainable. Now, there is a recent judgment I believe it's authored by Justice Dipankar Datta, who was our Chief Justice, on the difference between maintainability of the writ petition and entertainability of a writ petition. It's a beautiful judgment. You must read it, because the Supreme Court has cautioned the High Courts also, saying that please understand the difference between a petition not being maintainable and that you would not entertain it for XYZ reasons. So that's something the courts also have to be conscious about. But I believe that this whole explosion of writ jurisdiction has happened because more and more people want redressal of their grievances, and it appears as if Article 226 is a shortcut to justice. So that's when the Article 226 court, the writ court, becomes overburdened. It's not just Aurangabad bench that I've seen. I've been lucky enough to be had an opportunity to sit in all the benches and also in Goa. And I've realized that all the litigants and through their advocates now have this belief that if you somehow are able to reach the 226 court, there is a shortcut to justice that may happen. But there are a lot of pitfalls in that. And unless you are prepared to study what the real cause of action of the grievance is, you will not be able to convince a 226 court that please entertain my petition or that my petition is maintainable. Now, I've seen this tendency in even public interest litigations, where, of course, locus completely takes a back seat. The jurisprudence that developed from early 1980s onwards, with even letters, postcards sent from jail being entertained by the Supreme Court directly. There was one famous case of Bhagalpur blindings. I had a senior of mine in college who's now a senior counsel in Delhi. His mother was the advocate on record. And I'm told that when that matter was entertained by the Supreme Court, the lady who was an advocate on record, she had actually called the victims to court and presented them before the court, Supreme Court in court number 3, and the judges were shocked and shaken by what they saw, the kind of blindings that had happened. And then, of course, consequential orders were passed. But you will see even in PIL, where locus then takes a back seat, there have been phases and phases of the manner in which the High Court and the Supreme Court and the High Courts have been entertaining public interest litigation petitions. You will see initially 1980s onwards, where letters, postcards were being entertained. The first phase was necessarily on Article 21, right to life, Article 21 of the Constitution of India being violated. That then merged into a phase where there were people who worked in different areas, including MC Mehta, for instance, in environmental ecology, where they came up with large number of petitions under Article 32 directly, saying that in public interest, please entertain these issues, dwindling forests, rivers being not utilized for the purpose for which they should be, etc., pollution, etc. That's roughly the second phase. And now, beginning of 2000 onwards, you will see a lot of PILs in Supreme Court and the High Court on transparency, probity, on integrity of the system in delivering goods to the people. So this is the kind of evolution that is happening on the PIL side as well under writ jurisdiction, with locus completely taking a back seat. But I have seen over a period of time as a lawyer in the Supreme Court and as a judge in various benches of this court that there is a tendency to misuse the concept of PILs. Private interest litigation or agenda-driven litigation then masquerades as public interest, and it becomes a task for the court to then find out what's happening in the background. Sometimes you have good assistance from the advocates from the government side to bring out what the real truth is. But if this is the kind of inquiry the judges are required to make, you will see that even judges, being human beings, they develop a tendency of suspicion. Every time a PIL is filed, the judge is looking at whether there's some agenda in the background, whether this is private interest litigation masquerading as public interest litigation. This happens more in the principal seat I have seen, because one decision going one way, unlike Aurangabad or Nagpur, where we are talking of a few lakhs or a crore, there are hundreds of crores that would be affected on the opinion that or the decision that the judges ultimately take. So that's why we have these public interest litigation rules now. And you must have seen in the past 8 weeks that I have been here heading court number 1. In at least half a dozen matters, we've invoked Rule 7A of the public interest litigation rules of our court, for the reason that we find at the backdrop there is somebody who claims to be a social worker, who claims to be a public spirited person, comes with a petition of hardly 10 or 12 pages, annexes some pages to it, documents to it, and makes all kinds of claims about corruption, about misuse of power. Although this is an era where this tendency is rampant, but still we cannot presume that all that is stated by the public interest petitioner is correct. So we've been invoking 7A and saying that show your bona fide, deposit a specific amount, and then we'll hear you. And we've seen out of half a dozen petitions, I think only one or two somebody came forward. Otherwise, all had either withdrawn or they've taken further time to think whether they want to deposit that amount. Why I'm mentioning this is that whenever a litigant claiming to be a public interest petitioner comes to you, you as an advocate must make an inquiry yourself, because ultimately you are the first filter for the court. I have said this in my earlier lecture 7 years ago here, that there is a report of the Law Commission, I think it's a 115th report, sometime in the late 1980s it was given to the government, which said that there is a crucial role performed by the advocates in reducing the pendency of matters in the court, because they are the first filter. We as members of the bar, we are supposed to perform a duty towards the court. There are in fact threefold duties, as we all know: duty towards the court, duty towards the litigant, duty towards the society, with the duty towards the court being the uppermost. The highest duty that of an advocate is the duty towards the court. Now, how does an advocate or a lawyer perform that duty? That when such a so-called PIL petitioner walks into your office, the first thing you have to do is make a bona fide inquiry yourself. Call for documents, find out whether there is real sincerity behind this cause that is sought to be raised or not. And if you are convinced, only then do you go ahead to file that petition. Because willy-nilly you will become a part of the agenda-driven or a private interest-driven cause that is being moved by the litigant who walks into your office. So even if the concept of locus is diluted and public interest litigation becomes a very powerful tool for the writ court to take up matters which otherwise have been languishing, a great disservice is done when the members of the bar become unknowingly, I won't accuse anybody, but unknowingly part of an agenda-driven cause or a private interest litigation masquerading as a public interest litigation. So these are safeguards that the court expects from the bar. I know the bar expects a lot from the court, and a lot of fast disposals are expected. Lightning justice is expected from a writ court. But when we look at, from this side, we look at exercising writ jurisdiction, we cannot forget that there are areas where, by law, the writ court cannot exercise jurisdiction. We all know those exceptions, but I'll just highlight some of them. Latches, for instance. I have seen in this bench there are petitions filed on the basis of some documents that are collected through the Right to Information Act. A hash is made of certain documents, and the cause of action is stated to be, for instance, 1980s, 1991, some acquisition took place, and we were paid compensation. But now we are entitled to rental compensation because possession was taken earlier, or that we are entitled to compensation for further extent of our land being utilized. For instance, road, there was a petition day before. 1991, a road was constructed, and now in 2025 February, when the road is sought to be widened, the petitioner comes to the court saying that in 1991 my land was taken and road was constructed, and therefore give me compensation. And the second part, namely that the widening of the road is now happening, becomes only a small limb in the petition. Is it hit by latches? You will of course find Supreme Court judgments saying that if somebody's land is taken without adequate compensation, although now it's only a constitutional right, not a fundamental right, under Article 300A, the writ court should look into the matter. And the question is, are we not overburdened? What is this happening? Is the litigant being fair to the court system? That The litigant will walk in any time that the litigant wants. Why not? Why today? Why not 25 years hence? And if the court starts entertaining all of this and forgets latches, then what happens? Because there is no limitation, of course, for exercising writ jurisdiction. But law laid down by the Supreme Court says you have to approach the writ court within reasonable time. Now, what is reasonable time? For instance, what is a reasonable man? I should say reasonable person, after gender sensitivity seminar that we had. Who is a reasonable person? That's under tort law. So, extending the concept to what is a reasonable time? What is a reasonable period for limitation? Is it not self-discipline? Is it not that if a suit has to be filed in most of the causes of action specified in the Limitation Act within 3 years, or say even 12 years in certain cases, would you not apply that analogy to exercise of writ jurisdiction? So reasonable time. And if that is exercised in a case, the illustration of which I just gave, would it be unjust, or would it be harsh on the part of the court to insist that please wake up at least within 12 years and come? So these are questions we must consider from the point of view of the court, because it's very easy for blaming the system. I have been a lawyer myself, and I can tell you that sometimes even I used to feel that the court system is not delivering. What is so difficult? But believe you me, you come on this side, you will realize that it is extremely difficult. Judges are human beings, they come from the bar. I remember Justice Bombay, the then Chief Justice of India, in his speech after taking over as the Chief Justice of India, had said that this is a coparcenary. We come from you. So it's not, there is no cross purposes here. We are all working together for ultimately the benefit of the litigant. But in the process, are we indulging in blame game? Are the judges saying that the advocates are not being sincere enough? Is there any grain of truth in it? Is the bar saying that the judges are not delivering? But there could be scope for improvement on both the sides. But the focus has to be the litigant. I believe I'd mentioned this in my speech earlier, that when I was a junior for about 10 years at the bar, in the Supreme Court we had very fine judges, one of whom was Justice Majmudar, S.B. Majmudar. He was the elder brother of the Majmudar who was a judge of our court. And if there was one judge I found in my entire career who was the personification of what a reasonable person should be, it was Justice Majmudar. So when he retired, I think we used to have a pandal on the lawn in the Supreme Court for farewell tea parties, and it was overflowing with junior lawyers because he used to be kind to us. So he, in his farewell speech, said a thing which is relevant even now, or even more relevant now. He said that he said some Sanskrit shlok which I don't remember, but the meaning of which was this, that the court is like a temple of justice, where the judges are supposed to be gods who are dispensing justice. The counsel, the lawyers are high priests who are trying to convince the court as to where lies justice, guiding the court, guiding the gods about where justice lies. And ultimately, we all exist for the yachak, the person who enters, the litigant who enters the temple of justice. But he said, look at our actions, all of us, and see whether we have forgotten the litigant completely. Because sometimes you feel that the court or the judges are so engrossed in deciding matters which they feel will lead to judgments of great importance. As human beings, there is a tendency amongst everybody to be remembered after their time. So are the judges too busy in giving importance to writing long judgments, going in history as as authors of great judgments? Is vanity taking over? Similarly, are the high priests and the junior lawyers who are briefing them more interested in the fee that they are receiving rather than the cause that they are espousing? Or are the senior lawyers, again, a shade of vanity, happy with the fact that when they stand, as opposed to a junior lawyer or somebody who's put in less number of years of practice, when they stand in the court, everybody listens with rapt attention? Is that what they are hungry about? And in that process, while the little clerk who's assisting the junior lawyer is interested in the bakshish that he gets if there is an interim order given by the court, all of this is happening, and in the process, are we forgetting the yachak? Are we forgetting the litigant? We exist for the litigant, and unless we work in tandem, cooperating with each other, and keeping the litigant always in focus, we will have failed in our duties. So writ jurisdiction is magical if it works, but it can work only if all the stakeholders perform their duty the way in which it is expected in a temple of justice, in a court of justice. So that's how writ jurisdiction works. It's very well to say that the court has immense power. The court can do, in England they say that the court can do everything under this jurisprudence except convert a man into a woman and a woman into a man. It can do everything under the sun. If that's so, it's said about their parliament also. But we are concentrating here on court and the power of judges, the privilege that the judges enjoy of serving the litigant ultimately. So, as opposed to appellate jurisdiction where you are necessarily bound by certain rules, etc., the writ jurisdiction is wide, but it is not limitless. It is not unbridled. It ought not to be unbridled because it will lead to some other shade of injustice. So, laches. Now, disputed questions of facts. Can the writ court decide disputed questions of facts? Certainly not. But the court is required to interpret documents. So long as the document is admitted, what is the purport of the clauses of the document is something the writ court can do under Article 226 of the Constitution of India. But the moment you cross that line and start disputing facts before the writ court, it cannot happen. And therefore, that's one limitation. But I believe the most crucial is existence of an alternative remedy. And that's when I come back to what I was indicating earlier, that the advocate, the lawyer must first look at where is the grievance redressal system for a particular grievance with which the litigant has walked into his or her office. If it pertains to, for instance, the Public Trusts Act, you move the authorities under that act. If it is Maharashtra Land Revenue Code, you move the code and exhaust the alternative remedy before you come to the writ court. If that is not happening, the writ court is getting burdened with matters which it shouldn't be considering. So it considers those. In the pressure of work, maybe some interim order is also passed, but ultimately it is found that the writ petition cannot be entertained. So the existence of an alternative remedy, of course, is a rule of prudence, not a rule of law. The Supreme Court says so. It's not a rule of law, but it's a rule of prudence. It's a rule of self-discipline that the writ court exercises for the simple reason that if the writ court keeps on usurping these powers, then the statutory authorities, the statutes in fact, may be rendered irrelevant. So, existence of an alternative remedy. You know the exceptions to that, of course, that if there is a violation of principles of natural justice, notwithstanding the alternative remedy, it can be entertained. Or if the order itself is passed without jurisdiction completely, of course, a writ can be entertained. Or if on the face of it, the order or the action smacks of bias, smacks of malice, still perhaps the writ court can entertain a petition under Article 226 of the Constitution of India. But as I was telling you a little while earlier, it all depends on the quality of assistance that the bar gives to the writ court, that the stellar quality of the jurisdiction will be preserved and maintained. If you bombard the court with matters which ought not to be filed or cannot be entertained, it becomes a problem because we are not living in a sultanate or a kingdom where the writ court just looks at the papers and throws them. Although you will see that since I've been heading the division bench here with the able assistance of Justice Khobragade, on first dates we have been dismissing petitions that the writ court can do. But of course, in situations where alternative remedies are available, or there are laches, or there are other exceptions to exercise of writ jurisdiction. But what I want to impress upon all of you is that we are all aware about the power of the writ court, especially the power to issue the writ of mandamus. But are we conscious about the limitations that the court has or must exercise in writ jurisdiction? If you realize that, you will never blame the writ court. But if you don't realize that and you feel it becomes your birthright to file all kinds of writ petitions under Article 226 of the Constitution of India, and then you face some kind of a resistance from the court, you start getting a feeling that this judge is negative, this court is negative, this court is strict. Now let's wait for about a few weeks when the bench changes, we'll see. And that's not getting us anywhere, because ultimately we are losing sight of why we are existing. We are existing to give justice to the litigant in the shortest time possible, and in such a way that the Supreme Court doesn't have to waste its time on such matters. Because I believe that Supreme Court is meant, I've practiced there for 20 years, I used to be shocked. Satbara matters reach there, all kinds of matters reach there, and the Supreme Court judges are sometimes really perturbed what's happening. They are supposed to decide moments, questions of matters of moment regarding constitutional law, have maximum time for constitution benches of 5 judges or more to settle issues that have been troubling the court for years. That's not happening because you have Satbara matters, you have revenue proceeding matters, you have all kinds of matters ending up in the Supreme Court. That is the reason why the Supreme Court has actually entertained a petition under Article 32 of the Constitution of India, suggesting that there ought to be an appellate court in between, a court of appeal like in England, and then the Supreme Court. So the Supreme Court restricted to only deciding matters of constitutional importance, which of course all again come down to Article 32, 226, etc., and the width of power that is exercised by the high courts, the constitutional courts, and the Supreme Court. So unless we are conscious of this, we will be, in a sense, doing a disservice to the wide power that the writ court has. I have realized this. I, of course, was sitting with Justice Varare in 2018, and as a junior judge, I used to pester him sometimes, and used to, you know his nature, he never used to get perplexed with my insistence, but I used to say, sir, how do we entertain this? So he used to say, no, Manish, let's wait, we'll see, we'll issue notice. So this is the approach. This is also can be an approach. But I really sat down with senior judges here in 2018 and put it to them that why is this happening? Because this is slightly different from other benches. Nagpur bench, principal seat, Goa. Goa is not a bench. Goa is High Court of Bombay at Goa. They don't like being called a bench. So we have to respect that. It's a joint high court of 2 states. So what is happening here? So I was told that you have to see the other side as well. That there is extreme poverty in this region. There are people who are not even aware about their rights. So ultimately, where do they take shelter? They have to come to the writ court for justice. So that's a point well taken. There's no difficulty on that. In fact, Justice Borde was the administrative judge in 2018 when I came here. And he said, Manish, you will not have seen the kind of poverty that I can show you, for instance, in district Bid. So I retorted by saying that I can show you poverty in Medghat. I can show you poverty in Gadchiroli. I can show you poverty in parts of district Gondia. But that cannot be a justification to move away from what writ jurisprudence is. It's a very good thought that the poorest of the poor, or the last person in the line, which the great Mahatma indicated to us, must be reached out to help fight injustice. But it has to be done in accordance with law. What kind of writ petitions are we filing here? So the other possible explanation that was given was that this bench, the history, we'll of course get a revision of that when we have the program for the anniversary of this bench, speeches by people who have seen actually how the bench came about, that there was a lot of resistance, then there were court proceedings, and ultimately the bench was established, which it should have been, because this area, of course, needed a bench of the High Court. But what was the spirit initially? That there was some kind of a anxiety that if there is not enough pendency, then will it be a situation where people will start shouting, let's wind up this bench? I don't understand who would have even thought of that. But if that anxiety is one of the possible explanations for initial leniency, let us say, and reaching out to the litigant, the poor litigant, to say that yes, we are here and we will help you fight injustice. But how long will it continue is a question we must ask ourselves. It's 43 years of this great High Court bench, 7 years for 50 years now, and now you cannot even claim that you are a baby bench, because we have a baby bench in Kolhapur now. So you are now the Dada. And with Kolhapur having taken 6 districts from the principal seat, I believe, I'm not sure, but geographically, I think Aurangabad bench must be catering to the maximum area of Maharashtra, and certainly highest in filing, because it was almost in tandem with one-to-one with principal seat. Now it is certainly the highest filing in the whole of the state of Maharashtra. But we have to ask this question to ourselves: is it a thing we should be proud of? Is it the number of filings that makes the bench great? Or is it the quality of arguments, the quality of the lawyers who constitute the bar, the traditions that we lay down for future generations? I come from Nagpur, and I come from a high court, because in fact, Nagpur High Court lost its glory when it became only a bench of the Bombay High Court. It used to be a high court in itself. CP and Berar, Nagpur, and you would be interested to know that the successor High Court of the Nagpur High Court is the Jabalpur High Court. I had an occasion to decide a matter where I was veering towards a particular point of view when I was sitting as a single judge of the Nagpur bench of Bombay High Court. And there was a strident opposite view that was being argued before me. And to support that, they were quoting Nagpur High Court judgments before me, pre-1960 judgments before me. When the Nagpur bench was yet to be established, it was a high court in itself. They said, you are sitting at Nagpur, the judgment is binding on you. But I thought that judgment was not really advancing the cause of justice. So what is the solution I could find? You have to always study, do some research. So I found out judgments, old judgments of our High Court, and even Jabalpur, principal seat of the Madhya Pradesh High Court, which said that a judgment of the Nagpur High Court is binding on the Jabalpur High Court, because Jabalpur is the successor High Court. It is not binding on the Nagpur bench of the Bombay High Court, because it is, once it merges and becomes a bench of the Bombay High Court, there is no precedential value of the judgment of the Nagpur bench, or of the Nagpur High Court. So in a sense, the Nagpur High Court in a way lost its glory when it became merely a bench, a permanent bench of the Bombay High Court. But still, because the High Court existed there for years, and fortunately for us, we had stalwarts who practiced there, there was a tradition imbued in the bar. I can agree that there has been a fall of standards all over the country, all over the world, and to that extent also of the Nagpur bar. But you still have some traditions. I was fortunate to be part of the office of Mr. Ane, former Advocate General, where these traditions were given a lot of importance. And we were told that what are the duties of an advocate? How do you, in a way, protect the court from frivolous actions, and therefore leave time or time to think for the judges to deliver justice and to deliver good judgments? So are these traditions being maintained here? Are they being created here? What are we leaving for the future generations? Are we living a tradition where the litigant, because the litigant doesn't know, he just knows that I want a solution, I want a redressal of my grievance. What is the duty of the advocate? Is it to simply draft a representation, give it to some authority, and then file a petition for an innocuous prayer of deciding the representation within a particular period of time? It may work in a particular set of circumstances. You can't say that this is not the way. But is it? If a litigant comes with a grievance which has a grievance redressal mechanism in a statute, appeals, revisions, etc., you just make a representation and then you file a writ petition. In the first week that I sat here, we dictated an order where 5th June 2025, a representation is made to, I think, the collector or the SDO. 6th June, because now we have digitization and timings, so we've taken that in order. The order must be uploaded on the website. It's just a 2-page order. 5th June, representation drafted and sent. 6th June, 12:53 p.m., writ petition is filed. It is mentioned and got listed because of some grave urgency that is mentioned, that is stated during mentioning. Now, during mentioning, the court doesn't have time. It wants, all right, let us give dates as early as possible. So it gets listed within a week of being filed. And what is the prayer? Decide my representation. What is this that we are doing with writ jurisdiction? And these are the petitions that are clogging the docket of this great bench of the Bombay High Court. Where is the time to decide matters of moment, decide the matters of a poor pensioner who really wants justice? What time is left for the court? representation matters. Representation after representation. Writ petition generating future writ petition and content petitions. This system is not to cater to the advocates. If you really consciously heard what the Chief Justice of India said in Kolhapur, he's in the context of Pune making a demand, he said that he has no opposition to that. And jokingly he said that they can get themselves attached to the Kolhapur bench now. But he also said something very important, that a bench is not for advocates, it is meant for litigants. So ultimately, service to the litigant. Is this a service that we are providing to the litigant? Is this the kind of writ jurisprudence that will develop in our High Court? That we file representation after representation, petition after petition, contempt petition after petition, without going to the meat of the matter. What is the grievance of the litigant? Is he finding a solution here? And after the third petition, if a bench tells you that your grievance redressal system lies in a statute and go there, what service have you done to the litigant? What does the litigant think about advocates? What does it think about the court? 3 times I'm knocking my head on your door, and you tell me after the third occasion that go to some other authority. But that's the rule of law. Are we trying to breach the rule of law for a shortcut path to justice and jeopardizing the power of writ jurisdiction? That's something we must ask ourselves. We as part of the system, when I say we, I have been a lawyer myself, and I don't claim that I have been some Mahatma, but I have come from traditions which teach me that first you have to advise the client. In fact, sometimes, because this is nothing. If you come to Delhi, you will find the kind of advice that is given to the client is shocking sometimes. That where there is nothing, a case is created, and suits, petitions, etc. are filed. You should see the kind of problems sometimes Delhi High Court faces or the Supreme Court faces. 32 petitions are filed like that. But if you look at those people, you realize that maybe you are better, but you have to be excellent. You have to be even better to ensure that the litigant is served in the right manner. We can't give a kind of feeling to the litigant that the moment you walk into my office, I have some magic wand of first drafting a representation, then filing a petition, and then ultimately getting a favorable order. What is a favorable order? The court is also, I have seen this happening here, that perhaps this has been happening here much too often. I've said this from the bench, that the advocate walks in, this is the prayer, the court looks at the prayer, the advocate doesn't open his mouth, the order is dictated, 2-page order, 1.5-page order, that decide the representation within 6 weeks, and the matter is over. What is this that we are doing? Are we using our grey matter? Are we deciding matters of moment? Are we deciding questions of law? Certainly not. And is the litigant being benefited? Again, certainly not. What is it that he gets? And in fact, we are putting the whole system, the education officers, the deputy directors of education, the directors of education, collectors, tehsildars, SDOs, into a kind of mindset that if there are 100 matters where the officer needs to look into the grievance of an individual, he or she will not look into it till the High Court passes an order. Because this has become the tradition that you go to the High Court, get a direction, and then the officer will look at it. So is this the kind of writ jurisprudence we intend to develop in our High Court? That's something which we must all think about. But leave apart that. As advocates, unless we have refresher courses for us, I was told by your president that there is a study circle that is proposed. There is already a study circle, I think, here. We have one in Nagpur, which was rejuvenated when Justice Killor was the president of the High Court Bar Association at Nagpur, where you invite senior counsels, where you invite not just designated senior counsels who put in about 25, 30 years of practice, and ask them to give lectures, to give a kind of dynamic understanding of the law, so that youngsters who enter the bar realize what is the role of an advocate. How many junior advocates are joining offices of seniors, staying there? It's important to, this is a kind of Guru Shishya Parampara. The bar cannot develop unless you enter into that kind of parampara and develop. Otherwise, youngsters today, with the advent of social media, access to software, feel that they know everything. And they are certainly better than us at their age as compared to what we were, because they have more exposure. They are tech savvy. They have software, the click of a button, you can get judgments, which I remember in Mr. Ane's office, we used to look for digests, quinquennial digests, and find out whether a judgment has been overruled or not, and it would take hours to do so. Now it can be done with a click of a button. In all of that, they may be good, but they are perhaps not yet good enough to ask the correct question to the software, because that you will know only with experience. That's where you need to associate with seniors. That's where the seniors need to guide the juniors and develop the bar, so that this amazing power that writ jurisprudence provides to the High Court under Article 226 of the Constitution of India is utilized as a weapon to hit where injustice is happening. I see a lot of pressure on young advocates to deliver, and perhaps in that hurry, they want a favorable order. It's not a favorable order. The favorable order is decision on a list between the parties, on a question, on a ground that arises, that ultimately leads to one decision, certainty on a particular issue, and development of law. Because you will realize as you grow in the profession that earning money is a very important consideration during your initial years. But when you by and by rise in the profession, you want a challenge. You want a good point of law to be argued, to be decided, law to be laid down, your contribution to evolution of law, rather than the money, because money then becomes just a consequence of what you are doing. And I remember Justice Lalit, we used to brief him sometimes when he was a senior counsel in the Supreme Court. He used to say that money ought not to be the focus at all. He used to tell so many juniors, lawyers who used to come to brief him from Mofussil areas, that you do your job, you do it with intensity, do it with honesty. And if you give an honest advice to your client and say, don't file this matter, or that there's nothing here, you might feel that somebody else has filed it and earned money, but that somebody else is earning money in short term and no reputation at all. Well, if you stick to your guns, you will have a reputation where people will come to you. And he used to say in Marathi, ki paisa tumchevar yun bada bada padel, पण वाट पहा. Have some patience and be honest. Because whatever we say, this is Kali Yuga or whatever, but honesty ultimately pays. So I would really emphasize, maybe I'm digressing from the topic, but I'm really moved because I feel there's a lot of potential here for justice to be done to the real needy litigant. But the path that is being adopted is correct or not is a question at least we must ask ourselves. I'm not saying that everybody is wrong, but are we asking this question? If we ask this question, we will improve. And if we don't ask this question and presume that this is the way it is, then there is no scope for change. I remember APJ Abdul Kalam, I think the finest president that we had in our republic. He was the first president who visited the Supreme Court of India for a lecture. And that was the first Nani Palkhiwala Memorial Lecture organized on the lawns of the Supreme Court by the then Supreme Court Bar Association. And when he came, we were juniors that time, we were highly excited to see the president come. And the tent was overflowing, and you had all kinds of decorations done on both sides. Obviously, the president was there, the Supreme Court Bar Association, the treasurer had opened the coffers and spent a lot of money. And we had a very nice stage set up. The president came, a diminutive man, very unassuming. And he started off by saying that, please remove all these decorations because I can't see all of you on the sides because they were obstructing. So he got them all removed. And all Supreme Court judges were sitting in the first row. And he said that I have prepared a speech. It is available on my website. He was tech savvy, so he said, it's uploaded on my website just now. You can read it. But I will not read my speech because I have seen you all here. I will say something from my heart. And then he talked about change, the need for change, and how, according to him, hope lies in the younger generation. And then I include myself now in that category, that we are the older generation. He pointed towards those sitting in the first row, then the senior counsel sitting thereafter, and we were way back. In fact, we were standing because there was no space. So he pointed towards us and said that I have hope only from you people, because all others are gone cases, he said. He included himself in that. He said, I'm the oldest, so I'm the worst. But he said, I have hope from all of you because there is still scope for change. He said, you are the people who have your children in their prams. You are the ones who will be taking them to school. You are the ones who can make a difference, not just to yourself, but to future generations. So then he, of course, gave his own vision about what justice is and how ultimately this profession, the legal profession, is the most precious of all professions in the society, because if you see the time we earned our independence, you'll be surprised that the Constituent Assembly was full of so many lawyers. And how is it that all lawyers came together for this noble cause? Because this is a profession which gives you exposure to society, the needs of society. You, through your profession, you are able to give vent to the grievance of the needy. All this is not possible in other professions. For instance, you may say a doctor also does that. He gives a solution to a patient who comes to him. But the difference between, say, being a doctor and a lawyer, fundamental difference which I find is, my elder brother is a doctor, is that when they are trained, when they are doing things, when my brother operates on a very complicated case, he would maybe call a colleague of his, they would discuss, and they would end up adopting a particular procedure. But look at the way our profession works. The court sits, lawyers come, and they show you completely diametrically opposite sides of the same issue. They will admit the facts. They will say, and they will not even dispute facts sometimes and say that we admit these are the set of facts, but look at it from this point of view. And I have had relatives, young children. My niece had once sat in my court in Nagpur. Very hard-fought matter, senior counsels on both sides, very contentious matter, difficult matter. I call them grey matters, where you are not sure, there's no black and white. So it was being argued, and the child followed it from the beginning to the end. And once the pre-lunch session was over, she came to my chamber and said that, why are you hearing this matter? It's over. It's clear as daylight what the lawyer has argued. I said, wait, come post-lunch. Post-lunch, the other side of the case was developed by the counsel for the respondent, and then the interveners came with a completely different picture. And at the end of the day, my niece said that, I wonder how you will decide this matter now. So I said, this is the job of a judge, which I of course love. But that's why I say to counsel that once these hard-fought matters are over, your job is over, but ours start. And I say so many times that when the judge is putting queries to you or to the other side, don't jump to conclusions. And I say this so often in hard-fought matters that even I don't know where the hammer is going to fall. So make your arguments with the presumption that the judge is open, the court is open to hearing you, but make your arguments focused. I won't make that grievance here, but if you come to the principal seat, and especially on the original side where I've been sitting for about 3 years now, that the counsel have a tendency of arguing ad nauseum, arguing for days, forget hours. I remember when first big case that I took up when my headquarters were changed, I went to Bombay. There were total about 6 or 7 counsel to address the court. It was a very interesting matter. And one of the leading, of course, I won't name the counsel, very leading lawyers, one of them, I asked him, sir, how much time would you take? So they said, on my part, I will take 5 days. So I thought, he said 5 hours. I said, 5 hours? He said, no, I'll take 5 days. I said, I'll give you 1 hour. So he was upset. He said that then I will have to return the brief. This is the death of oral arguments. I said, so be it. He returned the brief. I'll give you 1 hour. So of course, it was not 1 hour. He took about 2 hours. But then he prepared written notes of arguments. And the quality of the written notes of arguments was sharp, because that is how the court can instill discipline in the bar. But I tell you that this is something that you must learn from great counsel, that when you restrict them in their arguments, they're at their best. And their written notes are crisp, sharp. In fact, in Mumbai, in Bombay principal seat, I insist that the note must not exceed 3 or 4 pages, and the font should not be less than 11, because I know they'll reduce it to 6 and give it to me. So this is how there's an endeavor being made to give quality justice dispensation, but it cannot be done without the cooperation of the bar. The bar must rise to the occasion, and so must the bench. And when you say that there can be opinions about judges, about courts, you must realize that when you are testing a court, because see, the difference between a court and the bar or the judge and the advocate is that the judge is always on display. He's always being watched, he or she is always being watched, every moment is being watched, and you can have an opinion which you are entitled to. But can the court have an opinion about the advocate? Not much, because he won't be there on display all through the day. But the whole point is this, that when you say that this court is not good enough or the judge is not good enough, please realize that all of us are human beings, and the judges don't come from another planet. They come from the bar, and the bar comes from the society. And if you honestly ask yourself this question, what is the basic common denominator of the character and integrity of an average citizen of India? You will get the answer. If you look at the Western world, we say that, oh, they have economic prosperity, therefore they can afford to have. There's no question of somebody affording to have integrity or character. It's instilled, built by your sanskar. If you have it, doesn't matter. So what is the basic level of character of an Indian citizen? From there comes the member of the bar, from there come the members of the bench. So unless we improve as a society, unless we improve as a bar, we will not have the kind of members of the bench that you expect. So it's a concerted effort, it's a joint effort. There has to be reasonable expectation. You cannot have, I remember when Rajiv Gandhi was elected as the Prime Minister, I was a school-going kid. So I remember his interview. So he was asked, what is the biggest challenge you have faced in your 2 years of Prime Ministership? So everybody thought he would say allegations of corruption, drought, severe drought that we had faced during that phase. And without batting an eyelid, he said, the scary expectations of the people of our country. So those who are there at the helm of affairs are expected to deliver, but they cannot deliver unless there is realization of the fact that your expectations have to be reasonable, and coupled with the fact that you have to contribute yourself to the system delivering to the litigant, who is the ultimate recipient of the service that we are supposed to provide. We've seen how Justice Chandrachud, in judgment after judgment, in his speeches has said that we have to change the approach from courts being some hallowed space, members of the bar being special in the society, judges having some great privilege, to this being a kind of service industry where we have to serve the last man. We used to study NCRT books where we used to have the last talisman statements of the Mahatma, which said that every action that you undertake, please ask yourself this question, that is it wiping the tear of the last man in the row? If that is happening, then you are perhaps in the right direction. So writ jurisdiction, the wide amplitude of the power is something which you can read about in books, but in dynamic interaction, how the court exercises that writ jurisdiction, you have to realize that unless you bring matters to the writ court which are entertainable, there is going to be clogging of the docket of the court. You will not get the kind of service that you expect to be provided to the litigant. And instead of the power, the wide writ court power being exercised for the benefit of the litigant, it will be counterproductive, and that may lead to frustrations. So it's just a suggestion that you can have from your members of the bar, who maybe are people who are successful but now less seen in the bar because of the kind of crowds that we have. Call them, bring them out, ask them to give you refresher courses, ask them to give refresher courses to the judges, because I've seen that judges also become hazy, jarred because of the kind of pressure of work that's happening. So you need sometimes a break. I had organized, for instance, as the chairman of the Governing Council of the Government Law College at Mumbai, a series of lectures that have just started. And the first lecture that I insisted upon was delivered by Mr. Milind Sathe, the senior counsel. And I told him that since we have young students here who will be members of the bar in the near future, please tell them about the evolution of constitutional law in our country. And I just gave an introductory 5 or 10 minute speech, and he held the field for more than an hour. It was mesmerizing because he also printed a booklet of his thoughts, which he distributed amongst students. And it's a treasure trove of the development of constitutional law in our country. And that one and a half hour speech, really, if you are able to hear such speeches from people who have assisted the court in big matters like Ms. Milind Sathe has, you realize that how law has evolved, how we as members of the bar and bench can contribute towards further future development of the law, particularly in writ jurisprudence. All the best to all of you. Thank you.
Thank you so much, sir. We'll try to be excellent. Your insight on the topic of writs were not only the brilliant, but also incredibly practical for our profession. We are all deeply enriched by your knowledge and time. Now, I request our bar secretary to express our gratitude and deliver a vote of thanks.
Our guest, respected Honorable Justice Shri Manish Pitale sir, esteemed members of our bar associations, on behalf of High Court Bar Association, Aurangabad, it is my proud privilege to extend heartfelt vote of thanks. At the very outset, we are deeply grateful to Honorable Justice Shri Manish Pitale for sparing his valuable time and gracing today's occasion. His illuminating lecture on the topic of writs has enriched our understanding of constitutional remedies and extraordinary jurisdiction of the High Courts. The clarity with which His Lordship explained the evolution, scope, practical application of writ jurisdiction will undoubtedly guide us in our professional practice and enhance our approach while assisting the court. We also thank all dignitaries, senior advocates, and the members of bar for their presence and active participation, which has made this program meaningful and successful. A special word of thanks, appreciation goes to our organizing team and supporting staff of High Court Bar Association, whose efforts ensured the smooth conduct of today's lecture. Lastly, I once again express our deep sense of gratitude to Honorable Justice Shri Manish Pitale for this inspiring session, and I look forward on behalf of entire bar to more such enlightening interaction in the future. We assure that we will clear the luggage of matters on behalf of Bar Association during the course, and during the session of your course, my lord. Thank you.
Thank you so much, sir. Our committee has organized the tea and the biscuit. So everyone is requested to have a tea. Thank you so much.